All right, I think I will get us started. Thank you for joining us, everyone. I'm Daniel Zhang. I'm the Senior Manager for Policy Initiative at Stanford Institute for Human-Centered AI. And thank you for joining us for the Decoding the EU Artificial Intelligence Act event hosted by HI. As a lot of you may know, the EU AI Act is set out to be one of the world's first comprehensive legal frameworks for artificial intelligence. The AI Act was originally proposed by the European Commission in April 2021, and the general approach position on the legislation was adopted by the European Council in late 2022. The European Parliament just adopted its position on the EU AI Act with an overwhelming majority a few weeks ago on June 14. And I think we'll have a very great discussion on the implication of the EU AI Act, the Parliament position, and the implications. Now, let me introduce the panelists. First, we have Rishi Bommasani. Rishi is the society lead at the Stanford Center for Research on Foundation Models and a PhD candidate of computer science in Stanford. His work broadly focuses on the societal impact of AI, often by leading large-scale collaborations and building interdisciplinary teams, including introduction to the foundation model landscape and holistic evaluation of foundation models. He is also the lead author on a recently published blog post that examines how foundation model providers comply with the draft EU AI Act passed by the Parliament. And next, we have Alex Engler. Alex is a fellow in governance studies at the Brookings Institution, where he studies the implication of artificial intelligence and emerging data technologies on society and governance. He also teaches classes on data science and visualization at Georgetown's McCourt School of Public Policy, where he is an adjunct professor and affiliate scholar. At Brookings, Engler has written reports about the role of governance in AI oversight, such as by auditing higher algorithms and mandating AI disclosure. Next, we have Irene Solaiman. Irene is policy director at Hugging Face, where she is conducting social impact research and leading public policy. She's a tech ethics and policy mentor at Stanford University and International Strategy Forum fellow at Schmidt Futures. Irene also advised Responsible AI Initiative at OECD and IEEE. Her research includes AI value alignment, responsible releases, and combating misuse and malicious use. And next, we have MEP Dragoș Tudorache. Dragoș is a member of the European Parliament and vice president of the Renew Europe group. He is the chair of the Special Committee on Artificial Intelligence in the Digital Age and the LIBE Rapporteur on the AI Act. He sits on the Committee on Civil Liberties, Justice, and Home Affairs, Committee on Foreign Affairs, Subcommittee on Security and Defense, and the European Parliament's Delegation for Relations with the United States. And finally, I want to introduce Maricha, our moderator for the event today. Maricha is International Policy Fellow at Stanford Institute for Human-Centered AI and International Policy Director at Stanford Cyber Policy Center. Between 2009 and 2019, she served as a member of the European Parliament for the Dutch Liberal Democratic Party, where she focused on trade, foreign affairs, and technology policy. She writes a monthly column for the Financial Times and serves as an independent special advisor to the Executive Vice President of the European Commission, Margrethe Vestager. Maricha serves on President Macron's Tech Thinkers Advisory Council. And now I return to Maricha. Thanks everyone for joining.
Thanks so much. And I get to be Daniel's colleague, which is great, as well as Rishi's colleague. And I'm very excited about this panel today. Thank you all for joining. The panelists, the participants, we have a lot to talk about. Sometimes when I read about the EU AI Act in media, it sounds like the law is already agreed and in place. Perhaps it's a sign of excitement on the part of people who are hoping to see the democratic world putting up guardrails vis-a-vis this massively disruptive technology. But in reality, negotiations still have to start between the European Parliament, the European Commission, and the European Council. There seems to be, but I want to ask Dragoș for more insights here, political alignment and quite a bit of momentum. First of all, on the risk-based approach that the European Commission started with, but then also on the new addition of a focus on foundation models, basically to reply or respond to the breakthroughs in generative AI, which were actually not foreseen by the law. And that, of course, touches on a phenomenon that will likely be with us as we go forward and think about policies, regulations, and technology, which is that there will be new breakthroughs that change the status quo perpetually, and that it is very hard to incorporate every technology explicitly, even if there might be big effects foreseen. So I would like to start with Dragoș, and if you could lift the veil a little bit on what you expect from the negotiations.
Well, as I start, I expect to get everything that I want. Well, kidding aside, of course, that cannot happen. So as with every negotiation, I know that I'll have to concede on some points. But I think, as you also said very well at the beginning, there seems to be quite good alignment between what we did in Parliament and also what the Council did and what they are prepared to do. Because I think one reality that the Council is also well aware of is that we are no longer living in the same world as it was back at the time when they adopted their general approach, which was beginning of December. It might sound weird. It's been only 6-7 months ago. But I think we all agree that we did have an inflection point with ChatGPT. That meant an awakening at the top level, an awakening among our politicians. And that also means a change of heart in many governments in Europe who might have approached maybe the negotiation differently. And certainly so, it's true for generative AI. 6-7 months ago, the Council considered that there was no need to write anything in their position paper, in their general approach on generative AI, on foundational models in general, whereas we did. And clearly, there'll have to be some effort to bring the two approaches together. But from the signals that I get in the Council, the current presidency, the Spanish presidency, is already preparing a new discussion inside the Council to basically come closer to us. We'll see how close. I know I'm prepared to negotiate that part, just as I'm prepared to negotiate other parts of the text. There are 4 or 5 big pockets that I know will require some political wrestling, but all in all, I'm confident that by the end of the year we can make it. So I think the calendar that we have set as an ambition is quite a solid assumption, and by year's end, I'm convinced that this law will see the light of day.
Great, thank you so much. Could you briefly touch upon those issues of contention, just so that everybody has a sense of what you're anticipating?
Well, I'll start with the one that has caught the media line almost everywhere, which is AI used for biometric surveillance in public spaces. And more generally, I would broaden a bit the spectrum, because it's not only about that. We in Parliament have introduced quite a number of extra prohibitions for the use of AI, which I know are not necessarily to the liking of governments, because they have to do with exceptions for law enforcement in accessing and deploying some of these technologies. And I know that I'm a former Minister of Interior myself, so I understand rather well where they will come from with their arguments, and I'm prepared for them. And I know that there'll be quite a lot of negotiation going, but I can imagine already a landing zone for that. Therefore, while it's going to be a difficult negotiation, I know that we can find a middle ground. A second area will be around the regulation of high risk. What we did in Parliament was to introduce a filter. We allowed for a broader definition of use cases for high risk AI, but we have compensated that with a filter so that not all applications that would fall within those categories will actually automatically be condemned to compliance. They will also have to pass the test of significant risk. Whereas the Council still is, for the moment, in their logic of high-risk annex, and their attempt will be to narrow down those definitions, but that beats the purpose of the filter. So I know that we will have to discuss there, but I think the objective is shared between what we want to achieve with this provision, i.e. to again, not label unnecessarily applications as being high risk when they're not. And again, with a shared objective, I'm sure that we will find the means to reach a common ground. A third area will be around governance. I know that we have gone much further than the Commission, certainly also much further than the Council. We have introduced this layer of European governance, not only allowing national silos to develop in terms of implementation and enforcement, but also foreseeing a level of coordination to make sure that we have uniformity in the application of the law. I am convinced of the case that I'm making with this proposal for governance, and the signals that I get from the council are positive. So I think there, again, there'll be a bit of quid pro quo, but I'm convinced that we also can find agreement there. And of course, generative AI. Generative AI, where I don't know exactly how close they will come to us, but certainly this is another part where we will be negotiating hard. And then, of course, there are many other aspects of the law, the conformity assessment, the fundamental rights impact assessment for high-risk applications upon deployment. So there are many areas where Council might have different views and we will have to negotiate, but I think those would be an easier task of finding agreement than the rest.
Great, thanks. This is so helpful. Next, I would like to turn to Rishi, who has recently done fascinating research where he has essentially mapped out how companies that are developing generative AI would comply with the EU AI Act as foreseen. So obviously, we appreciate that there still needs to be negotiation, but his research gives great insights into how companies are faring with regard to these anticipated new criteria. So Rishi, do you want to share a little bit about this research and how you think that the EU AI Act can make a difference for people?
Yes, absolutely. So as Maricha mentioned, of course, there's a lot of uncertainty here, both in the sense that the AI Act will evolve over the trilogue, and also in the sense that the conduct of these foundation model providers will also evolve over time. But with that caveat in place, there's a variety of things going on here, and there's a lot of takeaways from that work. But to distill them, I'd first highlight that there are a few areas where we see that most providers are sort of not doing particularly well. These are in relation to sort of providing a summary of any sort of copyrighted data being used to train models. This is also on the topic of risk and risk mitigation, and then finally on the topic of evaluation and testing. And so in part that recognizes that in parallel to the AI Act, a lot needs to be done in terms of the development of standards in the space and the development of evaluations that these providers can use, and external testing and auditing mechanisms. So that's sort of one key finding in our work. A second that I'd also like to highlight is on the topic of sort of open source, and it's fitting that Irene has worked on a lot of different things here on the topic of release strategy. So in particular, we see that many of the providers that adopt more of a sort of open source stance, or generally open stance, tend to fare quite well on requirements directed towards the resources that their models require, so the data and the compute, whereas more of the sort of closed or restricted access providers like OpenAI and others perform better in terms of the requirements directed towards how their systems are being deployed downstream. And so I think this will be an important area for understanding how the AI Act evolves and how the requirements are distributed towards open source providers and less open providers. Overall, I think the AI Act is at least in Parliament's version, if successfully enforced, likely to improve the status quo, because there's a lot that is not transparent at this moment broadly in this ecosystem. And I think that is sort of an essential precondition for making progress in this space. And so I think the Act's focus on this topic is quite helpful and quite timely.
Thank you for that. Are there also areas that you have researched that you think are strangely missing from the draft EU AI Act, that if you had a seat at the table with the negotiators, you would say, hey, why don't you focus on?
Yes, so of course, I think the Act covers a lot, but of course, there are many other things it doesn't cover, and the sequencing of how these will be addressed over time is an important question. Two things I'd like to highlight here are first on the topic of sort of how these foundation models are being used. Something we know from regulating and reasoning about online platforms like social media is that understanding how platforms are used, and a lot of the work that has gone on platform transparency and has been written about by scholars like Daphne Keller and many others, indicates that reporting of this type of transparency of how the platform is used is essential for guiding a lot of the work on understanding the platform. In the same sense, there's a question of how are these foundation models used, right? If something like ChatGPT is being used for medical applications versus legal applications versus entertainment, this materially influences how we reason about the technology. And so having that type of transparency, I think, would be a useful piece. And the other thing that I'd highlight here is that there's this sort of broader ecosystem in play, and the Act already sort of significantly addresses this by recognizing that foundation model providers have sort of requirements towards providing documentation downstream. I think what I'd like to see in the future is also understanding of how other aspects of this supply chain need to be connected, right? How does accountability transfer from sort of downstream actors upstream? How do we think about topics like redress or harm? So I think that is an essential piece that I think will come in the future, but is also a topic that I think is important.
Great, thank you so much. And we actually have the opportunity to do a briefing for some of the lead negotiators tomorrow, so I hope that will be enlightening. Let me now turn to Irene and ask you what you see as you are thinking about all these governance questions from the side of a company, Hugging Face, but also looking at a set of very powerful companies and their decisions in the absence of a law on the books at this moment in time. What are your observations? How do you think the EU AI Act will impact your life? How are you considering what is responsible? What is risk mitigation in the meantime? Share with us a bit about what you're seeing in the private sector and the governance that they are performing.
It is crazy to try to do this in an hour. I'm going to try to distill as much as I can. And it's always hard to follow Rishi, but I have so much to say that he hasn't explicitly cited yet. So I'm excited about that. So we know that tech needs good regulation. We need to be guided in the right direction, and especially to have some coherence among different tech companies, even with similar ambitions. Law must also be technically informed. I'm a big fan of the risk-based approach, especially for these increasingly multi-purpose or general purpose systems. But I think that policy and law should not be informed by, but should take lessons from where the research is. And so the 3 points that I'm particularly interested in are on transparency, model access, and on impact assessments. When we're looking at transparency, the great work from Rishi and Daniel and the team at Stanford on scoring foundation models really digs into what transparency looks like, but also where are we in standards for what transparency could be for documenting data sets, documenting models, but also documenting processes. Big Code, which is hosted by Hugging Face and ServiceNow, is piloting a governance card that goes beyond just documenting the explicit components of what goes into training a system. Another citation of Rishi is ecosystem graphs. I think it's really helpful to visualize how a specific system is being used per application, especially when it was not built for a specific application. The second point on model access, I and Alex think a lot about. Researchers just need access to systems for conducting evaluations, for building safeguards. And Alex has some great work on what ripple effects could look like for the EU AI Act in the open source community, but it is something that I am deeply concerned about. And the third is my research baby. I think all the time about impact assessments. And there's great work from Rishi, from Google, around Helm, the holistic evaluation of language models, and Big Bench, but we don't have standards as a research community for what evals look like. We don't have consensus on what capability looks like. And where we are on impact assessments is frankly really rough. There's not great ways to robustly evaluate even one aspect of bias for a language model and then forget about audio generation. And we're like very, very early days in image generation. Some lighthearted.
Oh, that was very
there.
No, that was very rich, and I want to ask what you would tell the EU negotiating team as your priorities? If you had a magic wand, what 3 things would they solve for you?
Transparency, model access, and impact assessments.
Great, thank you. And you expressed concern about the way in which the EU AI Act deals with open source. Can you share more? Why are you concerned? This is a big discussion. I think it'll be helpful to spend some time unpacking.
Well, I want to tag team Alex on this as well, but it's just a really complicated question because not everything should be open source to everybody. I mean, it is a signal that Stability AI staged release their latest model and didn't immediately make it accessible to everybody. The problem is that we don't have a good threshold, and this goes back to impact assessments for determining what is safe for anybody. I don't think that there is any anger that Elmo or BERT or even GPT was originally open source to everybody. But where it gets kind of dicey is around novel modalities where we don't have as much literature on risk, like Make a Video from Meta, although Meta has had a track record recently of being pro open source and working on really impressive systems. They stated in their Make a Video release that they are not making that accessible because of unknown risks. So it's very, very complicated, but researchers at FACT and RightsCon recently in the past month, I felt were overwhelmingly, rightfully afraid of this concentration of closedness, of not being able to conduct their research anymore. And to build safeguards like watermarking, researchers just need access to systems and their components.
Thank you. We'll talk more, I think, about this notion of concentration of power. But first, I want to turn to Alex and ask if you could share your thoughts on the discussion so far, and maybe also incorporate the transatlantic implications, because there are dialogues going on between the EU and the US. AI is one of the hot topics. The US doesn't have a law forthcoming. As far as I'm aware, it has instead focused, the Biden administration instead has focused on enforcing laws that are already on the books and doing so as it was declared by a number of departments with the full force of the law. Can those two work together smoothly, or is it going to be a challenge for the US to not have an AI law explicitly? And what do you see as the dynamics there?
Sure. So if I just to comment on a few of the things I've heard, some of the really technocratic pieces of the AI Act are incredibly important and not yet decided upon, meaning we're going into a trilogue with 3 political institutions that have put forward 3 different versions of the act that really differ in some absolutely core ways. And I just want to mention, Dragoș just mentioned the definition. That's a great example. You can read the council version of the definition as only really being about machine learning, or maybe a little broadly, algorithms that change. And the word infer can be very important in that definition. Things that sort of change or adapt or maybe learn on their own. Whereas the commission is a much wider definition, the parliament also a wider definition, with an added sort of threshold of risk, I think, which is, by the way, I think probably the most flexible path forward. So it's interesting. I know there's a lot of other specific issues to talk about, but it's worth noting that some of the absolute core is still up for debate, including what type of agency and how many agencies in each member state are going to do this. Is it going to be that some existing agencies, like an employment agency, handles employment algorithms and an education agency handles education algorithms, or is it all going to be done centrally in each? There are some pretty unresolvable trade-offs. It's good to have domain experts do domain-specific algorithms, education for education. That being said, you also have to hire many more algorithmic experts to do this. And so I actually sort of very much recognize that live facial recognition and foundation models are in some ways the flashier, like more newsworthy topics. But they're absolutely like core technocratic pieces of this that I almost think need to be highlighted and worked out first, because they're about the absolute core function of the law. So wanted to highlight my boring technocratic stuff, but on to the fun things. Yeah, very much endorse what Irene was saying. I'm happy to be a little less nuanced here. I think a full open source exemption is worth doing. That is not for their use, but for their development and for their availability online. They're incredibly important to academic research. to public scrutiny and understanding of these models. It is a pro-competitive practice to allow open source. The absolute biggest competitor to concentration in AI companies is absolutely open source models, which are free and easier to deploy every day. And I think you actually catch a bunch of applications you don't mean to if you include open source foundation models. It's very easy to reuse them in trivial ways and still get caught up in the regulation if it's such a wide net. Now I could talk about a lot of these little things. I'll leave it there. I do want to say that there is a growing disparity between the US and EU approach, between the GDPR and data privacy, the Digital Services Act, which governs online platforms, the Digital Markets Act, which is more towards online e-commerce, the AI Act, paired with what will come, the AI Civil Liability Directive, and a few other pieces of related legislation. The EU really has a comprehensive legal regime for almost every sort of particularly significant use of algorithms that you can think of. And I just named 4 or 5 things that are all completely absent in the US. And I think if you're in the US and you believe that we need one of these or some of these regulatory regimes, which I do, we're experiencing these harms from AI that drive this demand just as much, if not more, than Europe, right? It is worth noting that it actually gets harder to do that when Europe passes these laws. That's not a reason for Europe not to do it. It is a reason for us in the US to be introspective. It's because companies are not going to want to follow 2 different standards in 2 different, very important markets. So it becomes harder when we pass legislation because we have to look to the EU and make sure that we're some level of convergence, some level of alignment. And the reason why it's not even really on its merits is because the corporate interest will fight tooth and nail if you pass 2 dramatically different standards for online platforms. And that's just a political reality that we have to deal with. So I do hope the Schumer process, Senate Majority Leader Schumer's got involved, starts leading us down this direction to new protections, but we do need to understand and watch the EU AI Act, make sure that we recognize what it's doing, look to things like standards and like the Trade and Technology Council to make sure we can build a path to alignment and create laws that people won't fight tooth and nail for us to implement and get some of the protections that Europe is passing.
Thank you so much. I want to reference a couple of responses to the process so far. So on the one hand, there are concerns expressed from the private sector in the US, but also in Europe, with voices who say if the EU passes this law, it will basically place itself outside of the game of ever developing foundation models or generative AI big success stories in industry. There are also those who say, well, if you look at the harms already and the risk, I'm not talking about existential risk, but risk and harms involved with generative AI and what it can mean for society, even as it stands now, this is not an aspiration Europeans should have. They should not look to Silicon Valley once more and wonder, why do we not have the same kind of big tech, but really go for something else. And then we had the curious kinds of responses of Sam Altman, for example, who was asking for regulation in front of Congress, but then said, no, not that kind of regulation when it came to the EU AI Act. So, the anticipation of what the act will mean for industry, for innovation, but also for the unique sort of position that the EU takes are at times also very critical. So I would love to hear from panelists, and you can just raise your hand if you want to respond first, what you think about this. Is this politicking? Is this the lobby as we might expect? Or is there really something unique going on around AI, and particularly generative AI? Dragoș, maybe I'll start with you because I'm sure you've been lobbied to pieces on this piece of legislation.
Well, what can I say? Yes, I have been. And of course, I saw the reactions over the past couple of months. I saw the reactions of those who said, oh my God, the end is near, and therefore please come and regulate us quicker. And of course, the recent letter from a couple of days ago of some, actually quite a lot of businesses that have signed up on the letter, so I take it very seriously, although I think that many of those that signed the letter did not actually bother to read much of the text. I close that bracket either way. So I put that.
That does happen. It's true.
No. I know it happens, and I know exactly also who are the authors of that letter, and I know exactly how they feel and why they feel it, because I did talk to them before. And I don't want to be mean, and I don't want to make to put anyone in a box. But anyway, I think there are, of course, many interests at play here. And it's always like this when such a fundamental piece of regulation is being negotiated and hits the market. So I'm not surprised. In fact, I must say that I've been surprised over this time preparing and negotiating this law the other way around. I've been surprised actually of how many companies, big and small, how many developers, including of foundational models and generative AI, have actually come and said, listen, we believe that we need to raise to a standard. Because I might have ethics of my own, but the company next to me might not. I might have a moral compass that tells me that I cannot release this product the way it is because it brings about risks, but the company next to me may not. And since we are in a very competitive market, if we have no rules, if we have no standards, then we have a risk to the bottom. And I've heard, again, I think much more of the industry than ever before with any other piece of digital legislation that have said that with this legislation, we are hitting the right spot. Of course, there are many things in this law that are not perfect. And I hope that in the negotiations to come, we keep, and your views, by the way, and your contributions are more than vital to make this as good of a law as possible. Understanding also, linking also to convergence and to the question earlier to Alex, understanding also that this model, good or bad as it will come at the end, will serve as a model. And of course, it's going to be difficult, and I very much agree with what Alex said, it's going to be very difficult for the US to take a different path, because there are going to be a lot of companies who will say, don't give us two different markets with two different sets of rules and two different standards, because that is going to kill us. And over the last 2-3 months, I have been approached by governments in many corners of the world who actually are, as we speak, looking at what we do and starting to replicate this model from Brazil and Chile and many other jurisdictions around the world who are starting to consider legislation of their own and are looking at this model. Again, I think that brings a level of responsibility on our shoulders bigger than if we actually needed a bigger burden than the one we have already, because we absolutely have to make this stick. We have to do the right thing with this one. We have to make sure that we leave as little loopholes as possible, and that we also cover for those aspects that were also raised earlier by Rishi, by Irene, by Alex, because again, we can't afford to make mistakes with this one. And as to the process on the US side, there is now, and I felt it when I was in Washington a month and a half ago. In fact, it happened that I was in Washington just at the time of the hearing of Sam Altman in Congress. And I was invited by the two co-chairs of the AI caucus in Congress to attend, not the public hearing, but the discussion that they had the day after. And listening to the congressmen and women there, speaking to some of them, I got a completely different feeling that I was getting months before when I was talking to them, and I would feel that there's just a handful of aficionados who are paying a bit of attention to AI, but certainly not considering rules anytime soon, whereas now the wind was blowing from a completely different direction. It doesn't mean, of course, that there will be an AI bill in Congress like that, but I'm also looking forward to see what comes out of Schumer's exercise. I have been speaking to some people in Congress. It's possible that I might travel to Washington to have a discussion with a team that will be working on this. And what I hope is that we can find the political momentum to actually sit down and see how we can converge. Of course, the laws cannot be the same. We live in two completely different legal traditions. It's a common law system in the US, it's a civil law system in Europe. I say this all the time. I'm a former judge, so I understand a bit these elements maybe better than others. In Europe, you have to have detailed legislation, Because if it's not written in the law, if it's not prescriptive, then you don't have, as a judge, you don't have the liberty to play and interpret as you would if you're in the US. In the US, you need a completely different level of detail. You can do with more generic, more principle-based legislation. And there's a different way through courts that gets detailed and rooted in reality. So I think that accepting this diversity, we have to see how we can hit a common note in terms of the overall approach and the direction of travel, and then of course to work together on standards. That's an important element in this legislation. We have a mandate for standards. We didn't have a mandate for standards in GDPR, and I think this was a mistake. And I think one of the reasons why it's been so difficult also for Europeans to work with GDPR was that there were no standards. There were just legal definitions. That for many engineers out there trying to make sense of what they had to do, it was a nightmare. If you didn't have a lawyer next to you, you had no clue whether you were on the right side or the wrong side of the law. That cannot happen with AI right now. We need technical standards. We need technical standards that are developed with the industry, bottom up, very much an American approach, by the way. And I have been saying it, and I'm not shy about it. I think we need to also learn what is being done right in the US in terms of bringing in the reality check from the industry in the work that we do as policymakers. And I think that if we do that, again, also alignment and convergence might come easier. So again, if we're aligned on standards, if we're aligned on principles, even if we will diverge in the way our laws would look, the level of details in our legislation, I think we have a good chance to build convergence between the US and the EU. We cannot afford not to do that, because if our two jurisdictions do not show a common front on this one, understanding that this technology is a challenge for the whole world, for democracies and also for non-democracies, the technology is the same in China, by the way, I think then it's going to be very difficult to find some interoperable way of dealing with this technology at the global stage.
Thank you. Any others who want to come in on this point, the political context, the push and pull?
I feel like a bobblehead with everything that Dragoș is saying because I'm just vigorously nodding. I was just in DC. I can't remember, like maybe 2 weeks ago, my boss, Clem, the CEO of Hugging Face, testified to Congress. And exactly what Dragoș was saying, I was not used to this level of technical capacity in Congress a year ago. Very impressed at how quickly and exponentially the technical capacity has been scaling up in policy bodies. In just June, I was speaking with EU researchers in Civia, number 10 Downing in the UK, and in Congress. And it's really similar conversations we're having. So my not secret mission is to foster international collaboration. There's so much overlap here. The distinction, exactly as Dragoș is saying, is how do we respect those cultural differences, not just for the obvious partners, but this is a global technology, and often the global South is left out of the conversation. We need to ensure that innovation works for many peoples, but there's a lot of criticism of the bureaucracy that leads to international dialogue in a time where we don't really have that time. I'm happy to fly as much as I can to foster international coordination, and I apologize for my carbon emissions, feel really bad about it, but there needs to be a lot more dialogue than I think is happening now.
Thank you so much. That is helpful. Alex, do you want to comment on, both the sort of shared interests globally, but also the unique interests and the unique role that the United States plays with so many of these highly impactful companies in its jurisdiction? And, just imagine 3 years down the road, there is an EU law, there is no US law. Where will that put the US? Will it be great for market forces? Will it be incredible risk concentration for Americans first and foremost? How will it put American government officials in relation to negotiations multilaterally? Any thoughts on that sort of geopolitical dynamic there too?
Yeah, it's a good question. I should be careful not to overly prognosticate, but our absence of platform legislation and really the absence of very serious pushes on platform legislation in the US is concerning. And I start there because platforms simply are a trickier problem for international governance, for relations between countries. It matters less if a company in Spain makes an AI hiring system and then decides to sell it in the US, because their AI hiring system is going to have to be translated into a different language. Like it's the geography and the jobs that they're going to be selling it to are going to be different. There's a good chance that they would have to really rewrite the thing and then sell the version, a different version in the US, and the same vice versa. So a lot of software is already going through these sort of traditional trade sort of adaptations between countries. We already have a lot of rules and things around like medical devices that make it pretty possible to build one in one place and then sell it in another. A huge market between the US and EU in medical devices, all of which contain algorithms that most people could easily qualify as AI. So that, in that sense, some of this isn't brand new. Platforms really put us in a different place, where really it becomes much harder to put two totally different regulatory regimes on them. The US has unfortunately not seemed like it's going to do something really serious here. Even what I sometimes call the Schumerian efforts, this proposal from Chuck Schumer, hasn't really focused on platforms. It doesn't look like we're necessarily going back. And with some of the concerns we're hearing now on foundation models and on generative AI, those are very platformy. They're very often built into public-facing websites that want to operate both in the EU and the US. So I do worry that you're right that the default path, even if we get some sort of more specific AI governance, is that we still don't end up touching a lot of these modern emerging issues on generative AI and more broadly on platforms, which I think is maybe the big picture. This matters for a couple of reasons. One, we have benefited from mutually regulating things. We both have car regulators that can find safety issues with cars that drive both in the EU and the US. Also, same with planes, long-standing and collaboration on airline regulation. And that raises the chances that a problem in one country is discovered by the other, regulatory cooperation. Of course, the markets work better, very obviously. And we think about the size of the markets. The digital technology market in the US is almost 10% of GDP, which is enormous. And I think in Europe, it's closer to 5 or 6% in the EU. So the scale that we're talking about is also quite high. And that's all now. The last part I'll mention about this is that the number of platforms that are starting to do kind of more structurally important things is creeping up on us. We sometimes think about platforms, we just think social media. But LinkedIn is a social media platform that also does hiring. Coursera is a platform that also is a mass education system. Some of these new financial platforms, a lot of people do trading and online and finances on what are historically been a one-to-one interaction are now platforms. I do think there's a platformatization of a lot happening, and we're really very much ceding the governance of that to Europe in a way that might be harder for us to make up later. I think that's only a partial answer to your question, but I'll stop there.
No, I think that's great. I would add that we're also, well, I mean, the US is also leaving a lot of governance to companies, and that has its own dynamics. But I want to touch on a question that I saw in the Q&A, and I'm terribly sorry for all the participants whose questions will not be addressed because this is indeed too short and there are too many questions. It is about how should we understand research? First of all, who's able to do research, which is a long-standing discussion also at the university that we work at. You know, who is capable of developing these kinds of models, who has the compute, who has the data, as Rishi touched upon. But also from a legal point of view, would researchers be impacted by the EU AI Act? What are discussions there in terms of when a product becomes a product? You know, when it leaves the sort of ports of research and academia and goes onto the market. So maybe I'll start with Rishi, then go to Irene and then to Dragoș on this, because I feel like the question of, you know, when does an application become an application? When does it actually get used in the wild and create real risks for users outside of a confined context where ideally in the public interest, people can learn about how these technologies work. So maybe you can start, Rishi.
Great. So I think there are two pieces to this. First of all, there's the piece of researchers producing models for AI systems in various capacities and how that's interpreted. And maybe I'll touch on that briefly, but leave it to Irene and Dragoș to elaborate on that point. And the other piece that I think is also relevant here is the access researchers have to other entities' models in this ecosystem and the ability to inspect them. So on the first point, I think where this boundary is drawn will be important, maybe also relates to where and how open source is treated in this ecosystem, because there's often an interplay between research and open source. But I think in general, I would be hesitant of regulation that targets research and again, I think in this space, especially on the topic of foundation models, we've seen that the norms here are quite blurry in the sense that, earlier, maybe a year or two ago, I think many of the norms adopted in the space reflected sort of research mindsets that were established norms in, say, the AI research community or machine learning community that I think as these product models have been commercialized have quickly changed, especially when we're talking about industry research as opposed to research conducted by academics. On the latter point, and I want to go to Alex's point too on platforms here. One thing we again know from platforms is that researcher access and the ability for external entities to scrutinize these platforms has been very important. And we've seen that, for example, with the Twitter API or with other such mechanisms being less transparent and less available these days, this severely compromises the ability for external researchers to meaningfully provide scrutiny. And so in the same sense, when we're talking about foundation models or other AI technologies that are in the scope of the AI Act, having mechanisms for external entities and who is afforded the affordance of being a researcher is also relevant here. I think will be important, right, for providing this type of scrutiny. And this is something that I think should be prioritized, right? Because if we do not have these mechanisms for external scrutiny, I think we're sort of ill-posed for researchers and academics to meaningfully contribute in this space.
Thank you. Irene, what do you think?
I'm going to go backwards and start with researcher access and then talk about productization. So access to compare and inspect models is so important. And really, Stanford is the only place that I know has been able to do it. I use CRFM, the Center for Research on Foundation Models, as the gold star of being a trusted third party to get access to many different types of models that traditionally more closed companies don't provide that access. I will also say that Stanford is exceptional in many ways in that it does not represent a lot of academic institutions. It has quite a bit of resources, and this is not particularly scalable. But Hugging Face libraries, I mean, there's a reason I like my job. It's been hugely useful for researchers. Having a common resource like the libraries to conduct research is critical also for reproducibility. And then to productization, there's been a heavy shift, mostly around the end of November, some correlation with the big release there, from research to productization, and even research for products. People are really excited about AI because of its enormous potential. And when we're talking about regulation or even Senator Schumer's safe innovation, we want it to go in the right direction and we want it to help people. But a great quote from Clem's testimony is that we don't need depth as much as we need breadth now. You don't need a chatbot to be able to tell you the meaning of life if you're just using it as a bank customer service chatbot, putting it into the ether if there's good statistics. But in my experience on the industry side, I've seen a lot more people use small, cheap models because they're cheap to fine tune. They can be adapted to specific use cases. And what we really need is better breadth and expertise across different fields to figure out how can we make this work for people in a specific application.
Thank you. I'm just going to turn to Dragoș to ask about what the law foresees with regard to productization, but also access for researchers. And then I want to give panelists an opportunity to just do final reflections as we're already coming up on time.
Well, I'll start with access for researchers because I think that's a very interesting element that is missing, by the way. And I think none of you, or I don't know if anyone of you listed it already at the beginning, but I think you should have. And I'm going to give it a very serious thought to see how we can actually bring in the discussion. So that's already one gain for today's conversation. You've planted the seed in here. In terms of what we have right now, what we have is an exemption for R&D. We've actually had quite a long debate with the other political groups on how to handle research and development, and the solution that was eventually supported by everyone was to have an express exemption for that. That means that until and unless you are on the market, then you are in this R&D phase, in this R&D mode with the application. Therefore, the laws will not apply to you. So we have no definition of what that is. It is likely that we will actually have a discussion also with the council during the trilogues as to what actually R&D is. Are there any potential loopholes that are coming out from the very simple exception that we have right now listed, I think, in Article 2 of the text. But so far, what we have there is just this exception.
Great, thank you. Let me go back in the reverse order, I guess, going to Alex for some final reflections. So much we didn't touch upon. What is a burning thing that you want to share, or conclusion you want to draw, or a tip you want to give Dragoș to bring to the negotiating table?
That's tough. I'm not going to answer that. I'll try something else because I had a final thought that's burning.
Great.
I want to talk briefly about how we would do this in the US. I think that's the biggest question in the US right now. It is the most common question I get from Congress. And I will say the US government has a lot of people who've been thinking about this, but the other panelists are totally right. The congressional interest in the last 6 months has skyrocketed absolutely dramatically. And a reasonable first question is, what do we do here, right? If the EU is doing that, what do we do here? And it is an extraordinarily hard question. It's an extraordinarily hard question. It's actually maybe a little bit easier for us in the US, but it's still very hard. It's very, very hard in the EU. The advantage we have is sectoral regulators. We already have regulators whose job it is to pay attention to lots of different areas of sort of high impact socioeconomic decisions, which is a big core of what the AI Act does. In hiring, in employment services, in workplace management, in mortgages and financial services access, and healthcare provisioning, all of these things, we already have some regulation. At times, those agencies are not prepared in terms of expertise. They're to deal with AI. They're probably adapting old laws written 40 years ago, say from some of the major civil rights legislation that may not include the word algorithm or data or computer for that matter. And they might not have obvious authority, or it might be limited structurally in some way. And they might not have the right enforcement powers to actually go do anything about it. That's true in some form of most of the agencies. Now, we don't have to do something that coordinates between 27 member states. That's useful. But what we could do is make sure that those existing agencies are empowered to enforce current law and maybe a stronger set of guidelines around algorithms on sort of the AI in their space, right? And housing and urban development, make sure that rental and housing algorithms are fair. Can the Consumer Financial Protection Bureau really enforce laws on mortgages and financial decisions? Can the Department of Education have some role in how colleges accept people and charge tuition based on algorithms, et cetera, et cetera? And I would say the lesson from working on the EU AI Act is that we probably can do that. We can do that in a way that is a little more, gives a little more flexibility to our regulators so they can go make really specific rules in their area. And that's an advantage that we have. But it's still going to be very tricky to pass kind of broad-based, try to solve all of this at once legislation, which I'm sure Dragoș agrees with is a challenge. But hopeful that that's the sort of inspiration we can take from the EU AI Act, and then also somewhat optimistic we can find a path from there towards alignment.
Thank you for bringing that up. I actually think that European governments and EU negotiators can benefit a great deal from the notion of guidelines with regard to the application of existing law, because lots of existing law applies also in the EU, despite or even with the EU AI Act. And then secondly, to to really think about enforcement. This has been such a gap in many, many laws, right? That get announced with big press releases and then the attention fades away, but really the proof is in the enforcement. And I think that is another issue where all the capacities that you're hoping that the sectoral agencies will get in the US, EU enforcement and oversight bodies would equally need. So just flagging that for Dragoș as well. I'm going to go to Irene next.
So to go back to taking lessons from where we are technically on research, we need to, going back to three things, bring in experts to move forward a specific aspect of what is needed for policy. So when we're thinking about model access, the open source community is extremely distributed and it doesn't necessarily have representatives in the way that industry labs do. So being really intentional about that outreach for experts is critical here. So that's one, bringing the experts. Another way that we can move projects forward. I love citing myself. So my evaluating social impact work brought together experts across 4 different sectors to move something specific forward. Where are we on what are the specific social impacts that we need to be looking at that are not existential risk? And it can also help with enforcement because I'm really fixated on this. We are not in a great place for impact assessments. The second part is on international bridging. Plus 100 to everything Alex is saying, there needs to be less patchwork. There needs to be less patchwork in how companies are addressing the safe innovation path that we're all taking. And then exactly as you're saying, Marietje, guidelines. I really agree with everything in the recommendations from Rishi and Daniel and folks at Stanford on the scoring of the EU AI Act for foundation models. We need better guidelines on transparency. We need better standards, and it circles back to bringing in the right people to make that happen.
Thank you, Rishi. Final thoughts.
Yeah, I think all of this is great, and so maybe just on my end, I think the key observations, just to reiterate them, that have come up time and time again during this discussion are, first of all, the AI Act is a big deal. I mean, it's not just the EU, it's going to set a precedent broadly, it's going to have global influence, and I think we all recognize that. That's why we're here having this conversation, but just to reiterate it. And as Alex mentioned earlier in the conversation, I think the foundation models, generative AI, so on, get a lot of the attention and have, and rightfully deserve some, a lot of the consideration here, but there's a lot else in the AI Act, and I think we should pay attention to that because it's going to affect a lot of different sectors. And to build on that, thinking about how we are going to enforce it, and also thinking about how we ensure that we have the appropriate talent in enforcement agencies or in other agencies is also a critical piece here. I think many sort of shortcomings when we talk about a regulation of digital technologies that we don't have the requisite talent distributed properly. And then finally, maybe the last point I'd make is I think we can take a lot of lessons from platforms here, both in the sense that some of these foundation model providers are tending towards sort of playing a role of a platform, but also in the sense that the EU and broadly, there's been a lot that's been thought about on platforms on the topic of research access, on the topic of usage transparency, and even on the topic of the fact, as we've seen the DSA, that we can have the separation between very large online platforms and smaller platforms. So I think all of that is useful to think about as we move through this trilogue.
Thank you so much. Dragoș.
Well, for my closing, I'll stay on the issue of the US because, I mean, evidently, clearly, and understandably, this is a key interest for you. One argument that I'm using, and I think it works rather well with fellow legislators up on the Hill, when I'm trying to bring a bit of a spring in their step, is the risk of states waking up before the federal does. And the fragmentation, and not only the fragmentation that it might bring, but it's also the risk of AI becoming a partisan issue or an ideological issue. Because we live in a world where people are anyway, unfortunately, withdrawing more and more in echo chambers and in conspiracy theories. And AI has that risk of becoming a topic that gets to be ideological, that gets to be partisan. And I think the moment that happens, I think we all lost and we all going to lose. And I think the risk of states starting to have these sort of initiatives that are going to be also perceived or built through different ideologies that might be dictating in one state or another. And I think that represents something that the federal level should be very seriously considering. And again, every time I tell them that, I see that there is a bit of a twitch in the eyebrows, and I think that's an argument that they need to also consider. I agree with what Alex was saying. In my conversations, I see that this sectoral approach, this sectoral regulators solution is one that I think is considered. I don't know whether that is going to be the decision and the road to take, but certainly this is on the table, and also very much focusing on auditing and how to use auditing as a tool for that. I've heard it in various conversations. I think it's a serious, it's a part of the thinking there. And one last thing here is this solution, or this project, let's call it, that came out of G7. G7, I'm sure you know very well, because Margareta Vestager has spoken about it and was also part of the conversation in the latest Trade and Technology Council session in Sweden some weeks ago, was this idea of a code of conduct. This idea of somewhat plugging in this space, this empty space that we have right now in terms of rules. Even we, being most advanced, we're still going to have an empty space until the rules will actually come into effect, which is going to be maybe 1 year, maybe 2 years time. And the question is, what do we do until then? And can we not actually find a way to maybe work towards convergence differently? And the idea of the code of conduct came about at the G7. Vestager received some mandate, let's call it, to work together with her counterparts on the US side to propose a text. There are many governments that were present at G7, and at the G7, as you know, India, Indonesia were also invited. And my understanding from talking to Margareta is that there is already good echo in some of the governments that have been part of the conversation. They went deeper into discussing a bit the details of how it would look like at TTC. There is also now a broader outreach that Vestager's team is doing to bring in different views and different constituencies to contribute to this idea of a code of conduct. And I think these sort of initiatives can help. And I will end on this note and repeat what I was also saying earlier. There is absolutely no scenario in my mind that is a positive scenario where we'll end up with different approaches on this, or with EU having rules and the US having nothing. I think let's look with responsibility of what has been happening with data, and how many times we had to go back to the drawing board and invent something that allows data flows across the Atlantic, and biting our nails until the next decision of the European Court comes along. I don't think we want a repeat of that scenario with AI. We have a duty as policymakers on both sides of the Atlantic to make this right.
Thank you so much. We all have our work carved out for us. At Stanford High, we continue to try to bring the worlds of policy, politics, and technology closer together. And I think today's discussion was both an attempt at doing so and a reminder of why it's important. We also really appreciate the need for research in the public interest, and are trying to facilitate resources that go far beyond Stanford's own capabilities, which are both exceptional but still limited if you look at what is needed for all of society. Today was a great discussion about an urgent topic, and I can only wish Dragoș and the fellow negotiators all the best in incorporating the many requests that are brought to your attention, including today, and squaring them all with each other, and looking to the future for a sustainable law that hopefully will make people's lives better, but that will also allow for room for collaboration with the United States and other like-minded countries, because indeed this is a global problem. I realized that it is exceptional that we've spent 1 hour talking about AI and the word China has not been mentioned. So maybe that is a first and something to celebrate. I hope we can continue this discussion. I truly appreciate all of your time, because as this topic of generative AI and AI governance is so prominent, there is also a lot of demand for your participation and spending time speaking. So much appreciated, and I wish you a great rest of your day wherever you might be in the world. Bye-bye.